Number 5, on day 2 of the hearing, brings into the rezoning of land within Martin, Carterton, and Warrapid districts. This is the last session for the day, and we're on the penultimate matter, which is Jews Brothers. Welcome, Mr. Anderson. Welcome, colleagues. You've handed up some summary statements of Anderson.
That's right. There are a couple of summary statements. Well, one's a personal statement from Jews Brothers. So
I'll go to that one first.
Yep. Start with them. I can introduce them, and then mine's a statement that was issued on Friday.
That's good. Can I just, to the extent that it helps you in particular, can I just summarise where the panel's at on this?
It would be very useful. Thank you.
Okay. We've taken a lead from the Ms. Floon's statement, and we've had some discussions with her yesterday. You were travelling, I think. And
yeah, I that's the morning, but missed the important bit for me.
Yes, that's unfortunately. We position that. Just find it. Position that Ms. Floon arrived on is that he believes that the submission for the rezone has some merit, that she needs some assurance on 2 or 3 matters, and the panel needs the same assurance. In no particular order, although point number 1 is probably the first one, we need some understanding on the MPS HPL in the event that by the time we make a decision, there's no statutory follow-up to Chris Bishop's intention to remove Class Land 3 from the MPS HPL. And so what we need certainty around is whether the master plan for the aerodrome constitutes a strategic planning document or not.
I could probably answer that now. So we're going out of order in that my position from my evidence in chief hasn't changed.
I understand that.
And I think the fact that it's gone through the Local Government Act process,
yes,
included that consultation, and there's a master plan clearly outlines.
If I come back to that, I just wanted to give you a high level of where we're at.
Fair enough. Yep.
It would be fair that Ms. Floon's not there at this point. She's just raised the question quite rightly. So we've got a semi-contest going on there, and I just want to know how, want you to give me some ideas how we might resolve that. That's the first issue. The second issue is around the impact on roading infrastructure. The third issue is about the impact of mixed-use zoning or mixed-use zoning / precinct approach on the Masterton Town Centre. And the third aspect is whether the ancillary precinct chapter is within scope of the original submission. I think it is. Yeah. And what the process would be for finalising the details of that if the panel felt there was merit in doing so.
Certainly.
So those are four issues that we're up front of our mind at this.
Yeah. Okay. I think each of those issues are covered off in my statement as it's a response to Ms.
I didn't want you to respond to them now, but you know that's what we're thinking, so that when you get to read your summary, you can break away and speak.
It's on. Yeah. Okay. But first,
Ryan and Bevan.
It's actually Bevan. Sometimes I spell wrong.
Yes.
And so
yeah. So Bevan will.
We've got the assistance of thanks to Solitaire and Co. and Charles.
So we're Ryan and Bevan Jews, co-owners of Jews Brothers Limited, submit a 185 of the proposed district plan. We own 9.55 hectares of land that adjoins Hood Aerodrome, as shown in our submission and Mr. Anderson's evidence. We purchased the land in April 2022. At the time, of purchase, our intention was to use the land for the purposes outlined in the Hood Aerodrome 2021 master plan, with specific thought given to hangar homes and aviation related activities. From the time of purchase, we have been approached by a number of times by both local and out of town visitors who are interested in similar developments. To date, we've had 8 parties, which is actually more like 10, who have expressed interest in the hangar home potential development, as well as the potential aviation centre. In our view, the proposal directly achieves the master plan, the only impediment to this being the rural zoning of the land in the proposed district plan. We raised the zoning with Masterton District Council before the proposed district plan was notified. At this stage during 2022, former council planner Sue Southey suggested that our site be included as part of the Hood Aerodrome designation. This, however, was considered not to be appropriate. Instead, we were advised by the council that we should submit on the plan, and we're encouraged to employ the services of a planner, which is why Mr. Anderson is here with us today. In 2022, prior to the purchase of the land, we understand the council was offered first right of refusal, and the council declined to purchase the land. Despite this, subsequent discussions with council have suggested a desire to use our land per the master plan. This has included seeking first right of refusals on any leases or future sales of the land. We're concerned that this may impact the ability to realise full potential of our property and contribute to the aviation community. The council has invested over $7 million into upgrading Hood Aerodrome to improve the capability and resilience. We understand there's also additional $10 million from the Provincial Growth Fund for further upgrades. In our view, a well-integrated hangar home commercial aviation development such as ours would enhance the utilisation of the upgraded airfield and support the long-term viability without requiring the use of the council-owned land, noting that there is a taxiway drawn on the master plan connecting to our land, our site. In our view, we consider the council's proposed changes to landing fees highlight a current underutilisation of Hood Aerodrome. We consider that the rezoning of our land would directly contribute to increasing usage, activity, public engagement with the airfield, assisting the utilisation of the airfield. Our vision for our site reflects a genuine passion for aviation and a long-term commitment to the success of the airfield. We believe the rezoning will provide benefits to the local community economy through through tourism, business growth, increased interest in aviation. As this land is freehold, the rezoning as proposed offers a complementary and alternative way to the council-led development and initiatives. In summary, our rezoning is consistent with the council's master plan, makes sufficient use of private freehold land, supports increased utilisation of the airfield, and contributes positively to the local economy, to the local community. We respectfully request that the council and decision makers recognise the value of this proposal and the role it can play to advancing shared strategic goals for the area.
Thank you, Bevan. Ryan, did you want to add anything to that? Okay. And were there any questions of either Ryan or Bevan in relation to the estate putting forward planning matter?
Thanks, Bevan. I just find in paragraph 6, said that this is how I consider it to not be appropriate. Who and why consider it not to be appropriate?
Because a designation requires that the council buys the land from us. It has to be, for it to be designated, the council has to pay.
The council would become the requiring authority. So they would be the ones that would be required to, I guess, be the proponent of any development and the owner of that development. So any third party hangar home type development, which as an aside is provided for in designation 4B, would need to remain reliant on the underlying general rural zoning, and there's no pathway for that type of development under that. I lose you?
Can you repeat that?
Yeah, you've lost me.
Okay, so if it was designated, what Bevan was talking about was 8 parties being interested in the development of hangar homes, or he thinks it's possibly higher than that. And as well as this aviation centre that's been purported, which again is not a council led development. So council as the requiring authority would need to be the ones that make use of a designation.
Yeah.
Any third party that wanted to do the same activities as the purpose of the designation could not rely on it, and as such would need to be under the general rural zoning.
What's the current designation over the airfield and what does that mean?
Well, hang on, it's, yeah.
I think I've
These are
Deal with
the, yeah.
yeah,
Plans.
these are, and I think I've explained that in my evidence. I could let me find the reference. I think paragraph 7. So designation 4A, which covers the runway and the hangars. So basically the existing airfield operations are designated for aerodrome and recreation purposes. So the requiring authority, being the council, can use that land for those matters without having to have regard to the zoning. And then the land bordering Jews Brothers property to the north, that little sliver is designation 4B, which is for the purpose aerodrome and recreation air park precinct purposes, which in addition to activities relating to the primary use of the aerodrome includes aviation related activities that are secondary to the primary use of the aerodrome but have a functional requirement to be located on or adjoining the aerodrome, such as an aviation centre, museum and hangar homes. But for that to be realised, it would need to be a council.
It just wasn't the right mechanism to get
Yeah.
there.
Long way of saying it doesn't work.
Yeah. It's fine, and that's not the focus of this hearing.
No, but it's I guess it's shaped, the provisions that were put forward because the master plan doesn't differentiate between designation 4B and the Jews.
What I should alert you to at this stage is administrative matters. Councillor Bauer has declared a conflict of interest, so he's not sitting at the main table. Won't take part in any deliberations or decision making on this.
Mm.
And secondly, I'll be part of a panel that's I'll be sitting alone to consider the council's designations later in this month, including the Hood Aerodrome designation. Don't think that disqualifies me from hearing this. Any further questions of Bevan or Ryan in relation to the background to the land purchase, the council involvement, and some of the other matters raised in this brief statement?
Yeah, just in your paragraph 7, prior to you purchasing the site, council was offered the land and declined to purchase it. Yeah. And then the subsequent discussions that since you've purchased it, the council have now suggested a desire to use it as per the master plan, which means that they would have first right of refusal should they change their minds and want to purchase it off you.
Trying to achieve with other agreements like through the fence. They've tried to say that they want to have first right of refusal of any lease or any purchase of any part of the land.
Just a sort of underlying thing that's come about. Any attempt we've had to negotiate with council for sort of an access without changing the zoning, they've said, yeah, we'll give you it, but we want first right of refusal. So they've sort of said they didn't want it, but now they're sort of like, oh, hang on a minute, there's a lot of development possibly happening here. Maybe we do want it. So
Right.
Well, this is really side noise.
Yeah.
Yeah.
That's right.
Yeah.
Something that we have any jurisdiction over.
It's not.
no,
So let's just keep to the planning matters. And is there any other questions?
Sorry, another one. A taxiway is shown in the master plan connecting to the site. Can we see it on the map here? Is that, or is that only in the master plan and not on our mapping?
It's in the master plan.
We have a copy of that.
Oh,
It's attached to your evidence in chief.
Yes, page 4, the exec summary, the master plan.
This is the Becker plan.
This plan. We go up on the screen. I can,
yeah.
we see code B taxiway, which crosses the boundary.
Oh, yeah,
Yeah, that's the taxiway that's been
okay.
links Jews Brothers land to the airfield proper, I guess is both putting it.
Yeah, it's actually really useful seeing that up on the big screen. Thank you.
For future development.
Yeah, that's.
I just, yeah.
No.
It's been reaffirmed in the actual development that they're doing.
Again,
Oh,
Yes. Just
It's also been reaffirmed in their current design plan that's in place, in action at the moment with their development that they're currently doing. Groundworks is actually, underway as we speak, developing all of that with allowance for taxiways through.
Yeah. So at this point in the current plan, that code B taxiway that the mouse is almost hovering over is just slightly to the left. And that equivalent where that blue line is now is where the new access point has been proposed. And that's,
yes, and the red line there is,
Not just
yeah,
proposed.
sorry.
red line's the boundary of the
Yeah.
designation.
No,
yes.
Yes,
Boundary of the
designated
designation.
boundary, yes.
oh, sorry.
Yeah.
That's a ground designation.
Designate is actually 2 designation boundaries. It's probably better to refer to figure 1 of my evidence to work out exactly where the designation boundaries, well, not to work out, to see whether. You can see that, just looking at that, where that little sort of designation with the dog leg and where the mouse is hovering now, that's designation 4B. So that adjoins the southern boundary, and then designation 4A adjoins the western boundary of.
That's the remainder of it. So what's the historical reason for 2 separate designations?
One being the previous and long-standing airfield boundary, and the smaller lot being a more recently acquired lot at the time of the subdivision of our land and the sort of neighbouring larger titles there, which was about 6 years ago or 8 years ago that was completed.
So what's the yellow boundary?
So that's the original airfield.
Okay.
And then that slither, if you click up, the one that one there, click there. That's the one that the council purchased in about 2018, 2017.
And it's under development
Yeah,
now.
and that's the one that's being developed now. Originally, it was purchased for the purpose of the aviation centre, but that's since changed to now being hangars.
Yes. Must have gone through its own notice of requirements exercise post 2018.
They did that through their own separate.
Yes. Okay. And as I understand it, Wood Aerodrome have asked for both designations to be rolled over into the new plan.
Correct.
I think without modification.
That's right.
One final factual question for me is, if you're able to answer it, who was the preceding owner of the land when you purchased the land in 2022?
David Borman.
David Borman. Private landowner.
Yeah.
And what was the land being used for then?
At that point, he had an intention of building.
No, what was the current use?
Was just
Your land.
occasional bit of sheep grazing, and that was it. Basically, sitting there empty.
The whole 40, or more or less the majority of that corner, 40 hectares, had been owned by, long-term by the Southey family. It was cut up in about 2015 or 16. The 3 lots, 4 hectares that the council purchased, our 8-hectare lot, which was then owned by Dave Borman, and the corner side of 4 hectares. And so previously agricultural, but
Yes, so I've got, is there two 4-hectare parcels with it?
one being the northernmost.
Yeah, the corner one which has got a beach bed on it.
got pointed at.
Up there, do your Jim Hickey impersonation.
We're attached to the leg though.
At the table with you.
I don't know what's happened there. Anyway.
Out with all the cables as well.
There after that.
Yeah, so the Southey family owned this whole corner around here up to there, and they was initially offered as one lot. There weren't any takers. The council asked for this 4 hectare lot to be subdivided, to which they wanted to purchase. Then these 2 lots were made, sold to another private entity, and then to Dave Borman, who's a developer, with the view of having some airfield related but slightly more detached sort of situation.
So 4 hectares for the 2018 extension to the designation?
Yeah,
Yes. 4 hectares for that land and
Yes.
8 hectares.
Yeah,
and this is 1 hectare that was retained by the Southey family that we later purchased and re-amalgamated back to.
Understood.
Yeah.
Okay. And okay, that's very good background. Thank you for that. That's what your ground there. I think we've probably got I think we've got a better understanding of the background to the site than I had earlier. Clearly, my colleagues understand the site much better than I do, and definitely want to go and have a look at this site. Brian,
If we can go back, I don't know, we can go back to the master plan of the airport and the little taxiway going into that Code B taxiway.
Mm.
Those hangars that are shown on that Code B taxiway, they're proposed, they're not there yet. Is that correct?
correct. And it's going to be a slightly different layout to what it is now. It's perpendicular to how it is.
Yeah. Are we able to email that and get that pulled up?
Yeah. Ryan has the plan, so that piece of land currently under construction.
Yeah.
And Ryan has the plans for that, which we can make available, and if useful.
to Charles.
I've got the plans here as well, if you look.
Oh, we got them.
Yes.
Oh.
Just to see what
Hmm.
the Charles have got, whether it's the frame.
So that's
Ryan, we might have it already, I think.
Little square down concrete
Yeah.
between the hangars, is that right? That's separately owned as well?
It is. That's the one. So originally the guy that owned that had 4 hectares that went out to Mania Road.
Yeah, can that initial plan that shows the black outlines, if that's pulled up, that'll give a little bit more background again.
This is the-
Yeah, that's got it.
Yeah,
Perfect.
updated.
But what's this? In the early 2000s, Paul Buchanan owned this lot, which he still owns now, but also the parcel that comes out through here. So the council acquired this piece of land and gave him access through, because he retained an access sort of landlocking this area. So sort of a standalone piece that the council subdivided sort of outside of the standard rules of 4 hectare minimum lot size to enable them to get, I think, more or less this lot that would be in another map. But
And the access is off John
yes,
Concrete
concrete.
Road.
Yeah,
Okay.
Yeah, originally it was the
Which is-
way went out to Mania Road, but they had to move it.
yeah, from, so it's sort of a slightly messy
Mm.
line of acquisition. But yeah, this is the current plan that's being actioned at the moment with the establishment of a new sealed taxiway
Mhm.
and a slight modification to how that master plan taxiway is shown that runs through here is now proposed to be sharing or working together with Paul's access way. He's got a 30-metre right of way onto the airfield through this portion of boundary. So sort of, utilising a broader stretch rather than having two.
I'm guessing it's grass because it's green.
Yes, yeah. Which is favourable
Yeah.
for general aviation rather than the sort of heavy
Yeah.
aircraft taxiway. So
Okay.
at present, it's this area with the exclusion of this row of hangars is what's being done right now. Wow.
Yeah. As part of stage
Yes.
2. Yes, I thought I read that.
This is probably outline plan.
Yes. Oh, well, yeah, kind of this.
Outline plan for the designation.
Okay. And that's the approved plan, is it?
That's right.
Yes. Okay. It's useful.
It's really useful.
In the view with the hard stand taxiway that runs, vertically on the screen, that as sort of demand requires, there's a sort of, general layout that allows for that to be extended up into our land with the moving of the vehicle access, which is wanting to be kept separate from aircraft access to be able to just transfer further up.
Yes, and does fair to say that the master plan covers land covered by both the designation and land that's not covered by the
That's
designation?
absolutely right.
Yes.
Yeah. Also, another observation in this plan is the master plan, as well as that designation 4B, introduced the concept of the hangar homes, which the Jews brothers have spoken about, as well as an aviation centre, neither of which are provided for in the outline plan of works, but yet through discussions the submitter has had with other parties are still firmly options that are on the table to realise the outcome sought in that master plan.
Yes.
There's no planning provision for any of those
Yes.
sorts of activities currently.
Designation boundary run along, if you go from the side access point on Manoa Road, the desert down, is that the dog leg?
That's the dog leg there with the green.
Yes.
Yeah. That's the more recent designation
Yes.
for the line.
For- Yeah, that's 4A, is
4B.
4B,
4B.
Yeah.
2018. Got it. Land's the slightly, obviously the awkward shaped piece that accesses out to Manoa Road and South Road.
Yes. Okay, I think that's sufficient background. Thank you, gentlemen. Janice, we're onto the nitty-gritty of the planning now.
Certainly. So I'll start at paragraph 4
Yes.
of my summary statement. So Ms. Falloon overall remains unsupportive of the request, although I understand from our meeting and from your mention earlier that she continues to see the merits of the proposal. So I'll respond to each matter in her summary statement as follows. I agree with Ms. Falloon that the master plan seeks protection of the Jews Brothers Limited land for future aviation-related development. In my view, it indicates the type of development, being airport-related, commercial and hangar homes, and whilst vague on timeframes, is set from a timeframe of 2021 when it was passed by council resolution to beyond 2040 as it describes itself as a 20-year plus document. This timeframe is parallel to the implementation of the proposed district plan. In terms of the structure, during our meeting, I agreed with Ms. Falloon that the rezoning could be its own chapter as opposed to a precinct within the mixed-use zone. This could provide greater emphasis on the aviation-related purpose to the piece of land. And in doing so, I think that that answers your question around the viability of the town centre. This piece of land is very much intended only for aviation-related development.
We understand that intention. We just want to be assured that that intention would be delivered.
Yes, and I go on to say I am happy to work with Ms. Falloon to ensure that there's an agreed set of provisions that for your consideration that deliver that.
Yes, and when you say, I agree with Ms. Falloon that there's rezoning could be its own chapter, are you meaning an MUZ or you meaning something else?
I'm meaning something else, and I'll move on to that.
Okay.
Paragraph 8.
Well, you do. If option 1 was an MUZ, if there were a number of options, MUZ per se, but option 1 and option 2 was MUZ restrained by a precinct. Yes. Option 3 would be something you're going to go on to disprove. Thank you. That's fine. I just wanted to get that understanding before you moved on to it.
I'll explain how I got there.
Be useful.
Subsequently referred to the National Planning Standards concerning how the rezoning could be its own chapter. Section 8 of the National Planning Standards sets out the zones which a district plan can use. Table 13 in Section 8 specifies the zone name and description the authority can choose from. One of the zones is a special purpose zone, airport zone, which is described in the table as areas used predominantly for the operation and development of airports and other aerodromes, as well as operational areas and facilities, administrative, commercial and industrial activities associated with airports and other aerodromes. So my biggest grapple the whole way through this process has been trying to work out how the aspirations as set out in the master plan and the Jews Brothers submission can be given effect to within the constraints afforded by the national planning standards and the different zone types and the way that MDC has chosen to go about the planning for the site being a designation as opposed to a zone. Typically, special purpose airport zones provide for other regional aerodromes or airports around the country. There are examples I can think of where there is a zone, a special purpose airport zone and a designation over aerodromes. So that allows for that third party use of the land where it's not the requiring authority. And we haven't got that ability here because of the retained general rule. Turning back to my summary statement, the description provides for the outcome sought for the Jews Brothers land. Hence, I confirm my agreement with Ms. Falloon that the zoning could be its own chapter rather than a precinct. I note that the provisions included in Appendix B of my evidence in chief for hearing stream 13 provide the basis for a standalone chapter. Attached at Appendix A to my summary statement is the start of a reformatted version of Appendix B to my evidence in chief, which details how the precinct could become a zone. This includes the introduction of an objective concerning discouragement of residential activities, an enhanced policy for incompatible development, emphasising the avoidance of residential activities where it is not part of a hangar home, and non-compliant activity status for residential activities in the rule framework, as per Ms. Falloon's summary statement. Such a chapter would also remove Ms. Falloon's noted issue concerning food and beverage, which is not a priority for the Jews Brothers, but was retained given it could be an activity supplementary to an aviation centre, which should be provided for. As food and beverage is no longer being pursued, it shouldn't come to fruition. Should it come to fruition as a proposal in the future, it could be progressed via a resource consent. Amendments to the chapter when compared to Appendix B of my evidence in chief are shown in green. Now, this is a work in progress. I wish to emphasise that. I ran out of time. But I confirm, should the panel wish that, like Ms. Falloon, I'm happy to work together with the intent on achieving an agreed chapter for your consideration. I would also like to work with the asset manager of Hood Aerodrome. A request through Ms. Falloon was made for a meeting to occur post the issuing of the Section 42A report. However, given the truncated timeframe available, it did not come to fruition. I also note that Ms. Falloon makes a comment about the need for a definition of hangar home. Hangar home is a term used in the proposed district plan already in relation to designation 4B. In my opinion, should a definition be warranted, it should be hangar home means a residential unit that has an aircraft hangar as an integral part of the design of the residential unit, and the aircraft hangar has taxiway access to Hood Aerodrome. I've used the term residential unit, and you'll see I've underlined it there as it is a term which was already defined in the PDP. In terms of the other matters Ms. Falloon outlines, I make the following observations. Noise effects. Regarding noise, I continue to be of the view that noise R14 is appropriate regarding reverse sensitivity. The air noise boundary already extends across the majority of the Jews Brothers land, and I've included a figure there showing that those are the orange lines. Therefore, should the air noise boundaries need to be revised as part of the master plan implementation, which includes extending the runway further out to the east, it generally will not create any new encumbrance on Jews Brothers land. Impacts on infrastructure. At paragraph 50 of her summary statement, Ms. Falloon confirms council staff have advised there is capacity in the Three Waters network for the request, but note that extension of any services to the boundary would be at the cost of the developer. However, there continues to be disagreement between myself and Ms. Falloon, as you alluded to earlier, regarding traffic matters. In my view, and as per my evidence in chief, the transport chapter provides an appropriate framework for assessing any impacts on the transport network from development of the site. Further, like the water infrastructure, the financial contributions chapter provides a mechanism for the developer to pay for any improvements to the transport network. On this, I note that policy FCP1, which is titled Full Costs for Required Infrastructure for Subdivision and Development, specifically requires developers to meet the full costs of new water, wastewater, stormwater, and transport infrastructure associated with the subdivision and development, including linkages and costs of local upgrading of infrastructure where the new infrastructure is required solely to serve the proposed subdivision or activity. And this is implemented through standard FCS3D, which would need to be addressed for any application, which requires developers to pay for the actual cost of upgrading any existing roads, access ways, vehicle crossings, parking and loading areas in the subdivision or development and the council's transport network. Further, I am not sure what value a transport impact assessment solely of the Jews Brothers site would provide. The development of this land is in the context of the master plan. Any impacts on the road network would need to include the other land in the master plan. Finally, having consulted with the Jews Brothers, in terms of hangar homes, Ryan Jews, man who's been pointing out things helpfully on the screen, has informed me that a total of 30 hangar homes would be feasible on the site. Noting, of course, that there are different development options. This isn't the only one. This takes into account the roading needed to service the homes alongside the need for each to be accessible for a plane. So the yield's not your typical residential subdivision yield on a 9-hectare site because the taxiways need to be provided. Planes are a bit wider than a car, yes.
2 lots of them.
Yeah. When considering the high traffic generating thresholds in the PDP Transport Standard TRS29 and Table TR17, average daily traffic generation screening table, in either a mixed use or special purpose zone, 50 residential units would be needed to trigger a need for a traffic impact assessment. As 30 is considered the feasible yield, even if development occurred in an ad hoc fashion as highlighted by Ms. Falloon, it would not reach the threshold specified in the PDP. As per my evidence in chief, any other aviation related development on the site would also be subject to assessment against the transport chapter provisions. Overall, I remain of the view that any infrastructure effects resulting from development on Jews Brothers land are appropriately provided for by the provisions within the PDP. Turning to the MPS HPL. Finally, at paragraph 53 of her summary statement, Ms. Falloon questions whether the master plan could be considered a strategic planning document. I state here in my summary that I covered this extensively at paragraphs 47 to 61 and consider that the master plan is a non-statutory growth plan or strategy adopted by a local authority resolution which qualifies it as a planning document. And so if I turn to that part of my evidence in chief now.
Yes, it's probably paragraph 51 onwards.
See the head of me, sir? It is. So a strategic planning document is defined in the plan as any non-statutory growth plan or strategy adopted by local authority resolution. So I think that based on that, there's a clear aspiration for growth. That's what the purpose of Hood Aerodrome Master Plan 2021 sets out to achieve. It went through council resolution in 2021, and therefore, in my view, it qualifies as a non-statutory growth plan or strategy. I'm happy to take questions on that. I don't see why it wouldn't fit within that.
Rebecca said we agreed that it's not a future development strategy. That's the first.
That's right. Yeah.
So, therefore, it needs to be a strategic planning document. Identified in a strategic planning document as an area suitable for commencing urban development over the next 10 years.
Yes.
Or add at a level of detail that makes the boundaries of the area identifiable in practice.
Right.
So on the latter matter, the master plan does identify boundaries.
Does. Is that figure 1?
Yes.
said earlier, the timeframes are vague
The master
in the
plan.
master plan. How I've satisfied myself is around where, and it's at paragraph 58, the land is identified as being used in stage 2A as well as stage 3. Stage 2 aiming to enable development of short to medium term activities. The only specified timeframes are in table 1 of the Marshall Day report, that's in appendix C to the master plan.
That report forms part of the master plan.
Forms part of the master plan, so it's appended to that, which states stage 1 has been implemented within 5 years of 2021. Stage 2 also 5 years, and stage 3 within 20 years. So within that 5 to 20. So what's that? So we're already 5 years in, so that's within the next 15 years from now.
Stage 2 is 5 years.
Stage 2 is 5 years. Stage 2's been implemented on designation 4B now, as we've seen. And then the next logical step in terms of achieving the master plan is with that that taxiway being shown to the boundary of their land, I think is within the Jews Brothers site.
What about the wording non-statutory growth plan or strategy? Ms. Falloon has questioned whether it's a growth plan or a asset plan. What's your response to that?
And back to what the purpose of the master plan
Yes, just bringing it up. You direct me to a
look myself. So page 1.
It's one. Is that the X?
No. Page numerical 1, not run.
It's the master plan, yes.
Yes, so it's about it's a valuable strategic asset for the region. The master plan is about bringing NDC's vision in reality. So it aims to define the expected future use of Hood Aerodrome, and include the runway infrastructure, protect space on and near the aerodrome for future development in a way that aligns for a coherent future vision and layout, and then protect existing activities and define anticipated infrastructure developments in the short and long term. So those are the stated aims. I think that does qualify it as a strategic planning document. I don't think it's an asset management. To me, an asset management plan would be, this is the asset we currently have, and this is how we are going to manage it. There's an element of that, but it's more about how it's going to grow and expand. It's not about retaining what's currently there. And I think that's what, in my view, differentiates between what an asset management plan would be. I've limited experience with asset management plan, but from a sins one day I found myself on secondment at NZTA dealing with asset management, and it was very different to
Formed by the strategic advisory group.
very different to plan.
Is there any assistance on this in the last paragraph of page 1?
So once adopted, the aerodrome master plan will be reviewed and updated any 5 to 10 years to reflect new development that has occurred on the aerodrome and any changes to planning parameters, which may include the development strategy, stakeholder requirements, regulations, and aviation industry trends. It's unclear what the development strategy is, but it is noted that the report was proposed and is quoted in there by the strategic advisory group. So I think that again alludes to the strategic and growth nature of the master plan.
Paragraph also speaks about the development. Oh, typo in their purpose. There's a statement above the vision statement from the strategic advisory group, and it's the availability of development funding as an opportunity to prepare for the aerodrome for the future and stimulate further development.
One thing that Bevan's whispering to me at the moment about something we talked earlier on was there was this built on a previous 2005 master plan, which was never really implemented because the momentum didn't build, which is typically what you need an impetus for these developments to happen. That's happening now with Hood Aerodrome. And what's your comment about the shame?
But there is no other land that's accessible to the airfield that has a possibility of benefiting the airfield in the future. If this land gets developed for something else, there is no other land on the side of the runway that can be expanded without interfering with air traffic operations on the other side.
Or moving roads and all
Yeah.
sorts.
Mm.
You understand why we're
Yeah.
wanting to satisfy ourselves on this?
Absolutely.
Yes. Particularly given the current land use classification
Yes.
is, if there was, well, that would require an assessment under clause 3.4, I think. Yes. And you haven't provided that.
I don't think we need.
Because you're relying on the carve out, one of a better way of expressing it.
It's a great way to express it.
Thank you for that. That's been of assistance. And as I said at the start, that's the starting point for the panel. We need to be satisfied that we're in the tent.
Yes.
Or outside the HPL tent, if you like. Okay, just to check whether there are any other. Well, I've got some planning questions, but before I go to those, I'd like to see whether there are any questions. Can we just explore these, which I've categorised as three options? The original submission, which sought mixed use zone. The evidence in chief, which introduced the concept of a precinct regulating development within a mixed use zone. And presumably, I haven't read all the details like Anderson, but presumably it would be a rule when the mixed use zone says for purposes of this area, the following. Going to be in accordance with the precinct.
That's right. And with objectives and
Policies. So it's a carve out of the mixed use zone.
yes.
Yes.
The only reliance I left in was around visitor accommodation, if that was to be.
Yeah.
I think that is an airport adjacent activity, if you like, but probably not something that is.
This is an aerodrome.
Yeah, it is.
Yes.
But with a stated desire in the master plan to attract commercial flights back to Marsden.
Just out of interest, where are you on visitor accommodation under option 3, which is the airport zone?
We'll go back into needing a resource consent.
Let's
I'm not that far through it.
let's come back to that.
Would have been, but
When you mentioned it earlier, I wrote down activity status and policy direction. So yeah, I'll come back to that with you in a minute.
sure.
So this concept of option 3, a special purpose airport zones, new.
As it's come out of the discussion with Ms. Falloon.
Yes.
And
Okay, Ms. Falloon hadn't mentioned that specifically, and that's not a criticism.
No, and sorry, this might have been my misunderstanding, but I was focused on the precinct,
Yes,
not an airport zone.
that's fine. It's not a problem. If I look at my phone, it's 222 for some reason.
Angel numbers.
Anyway, that's an aside. First question with the airport zone is would that be within scope to give effect to the original relief?
I think it is. It's narrowing the relief down. So the relief that's been sought really is about looking for a aviation related framework for the planning of the site.
Okay.
And it's how that's being delivered is what I've been grappling with.
Yes.
But in terms of the outcomes, nothing has changed.
We would invite you to elaborate on that in a little bit of detail as an addendum it's an important issue. It's the same issue as the HBL one, actually. Before we go down the track of inviting you and Ms. Falloon to perhaps consider options 2 and 3 in more detail, we want to be assured that that there is scope to run with an airport zone as defined by the national planning standards. So that's a matter of looking at the relief sought, what the outcome of that release would be, and then explaining how the airport zone would achieve that relief, albeit in a different manner.
Yeah, I started off wanting to use the framework that was already
Yes.
put forward.
Presume, did you prepare this submission?
But
Presume you didn't consider what I'm calling option 3, the airport zone, because
it wasn't,
used, wasn't
it's not
used.
used in the plan.
Yes.
Yeah, so that's what I mean by trying to figure out what the master plan and the Judes Brothers aspirations for the site are. And I think those aspirations are entirely appropriate, but how that can fit within, firstly, the planning framework as put forward in the PDP, secondly, the planning standards, and thirdly, the way that the designation has been used as opposed to an airport zone, which would have been my preference up front, would be if Hood was special purpose zone airport, extending that zone through.
Could you give that some priority? And because we're probably going to direct some conferencing between yourself and Ms. Falloon for next week.
Sure.
And we'd like to, before we do that direction, we'd like to make sure, we'd like to see what you have to say about that scope issue first. I mean, there'll be conferencing regardless.
Yeah.
On just the precinct anyway, but we would like to understand the scope.
Realistically, looking at my week from here through to close of business Friday, it will have to be Monday.
So as long as it's so late, it
Waitaki district plan's also moving at pace.
needs to be a long piece of work.
Just need a,
Just explaining what the release and what the outcome of that release suggested,
yes, and
and whether and why this is another vehicle, a different vehicle, but would achieve the outcome that was specified in the release. Is that clear?
it's clear.
Then it's once that's known, I guess, and once you've undertaken newer discussions, we need to understand whether that's effective and efficient. And so you might want to canvass that in terms of 32 AA.
Yes,
Extending the 32 AA.
yes. So I provided one
I think you did.
with my,
Yes, but
but it will, that can change if,
that's right.
as we.
I mean, yes, each of the techniques will have a degree of effectiveness,
Yes,
as well as more efficient.
yeah, that's right.
The fact that the
Knowledge.
isn't a zone just sort of mixed use is the line in that precinct. Without reinventing the wheel. That's what I mean. Others, they haven't adopted it.
Having a query here concerning mixed use zoning as we originally, it's prompting me to think about what I'll be doing later on.
It's, the mixed use zone option 1 versus a mixed use zone precinct. They're two different things. It's essentially, as I said,
That's right.
it's a carve out of the mixed use zone.
Right.
This
It's already adopted by the.
special workfield airport zone is something another.
You.
And so apart, what the panel will also need to consider is, will it create a sort of an anomaly, having an airport zone
It's an airfield that's not.
next to an airfield that is designated but doesn't have an underlying airport?
Yeah, that's what stopped me from
Yes,
doing it in the first instance.
I know, but is it going forward for the panel's benefit, is that a problem? It's, we need you and to address that. Once you've got over the scope issue.
Right.
A couple other minor matters. So hangar homes.
Yes,
So they're actually residential units.
For the big garage.
Yeah,
Yeah.
a house with a big garage.
Awanui.
Yeah. Pawanui,
Yeah.
Whittianga, but that was done not so great.
It's over that coming up.
It's the place at Pawanui.
So are you familiar with the motorsport facility at Cromwell? Highlands Park?
No, it exists.
Yes. So they have apartment style living associated with being able to park your racing car or cars in large garages underneath.
That concept, I
That's
guess,
the
yeah.
same concept. Yeah.
And it can be anything from adjoining hangars with a, overnighter in the back to, a couple of 1,000-metre sections and nice house or whatever.
Is there, does the mixed use zone provide for residential units?
No, not that. That's why I couldn't get it to work
No.
appropriately. Yeah. It's what this has been my issue the whole way through is that it doesn't neatly.
Yes.
Anywhere.
Yeah.
That's why I think you're going to have to look very carefully at the relief that you've sought for a mixed use zone, then translating to either the airport precinct or the airport zone. And are you inadvertently or deliberately adding in activities that wouldn't have been reasonably known by somebody reading a summary of submission saying that you're asking for a mixed use zone?
Sure.
So it's going to need a little bit of forensic examination. The next question then is, what's the compatibility of residential units within the air noise boundary?
Yeah, and again, this is something I've thought about. Reverse sensitivity, and really comes down to what reverse sensitivity is in terms of will residential units that are part of a hangar home constrain the use of the aerodrome or not. And I think the fact that they have to be part of an airfield related activity means they do not constrain the use. In fact, it's the opposite.
You might have to convince us on that. Yep. And I mean, if I'm looking at the map on yours summary statement, page 3, which shows the annoyance boundary lines there. Is that, do you know what dBA that equates to? What level?
Not off the top of my head.
Probably at least 60 dB. Might be. Is it an outer or inner noise bound? Is it
The rule 14, which I've quoted, doesn't differentiate between what the different dBs are. It just requires a mitigation for when you are constructing a noise sensitive activity.
the Marshall Day report? The appendix
Does.
being assist?
Yeah, it does assist. Just looking at.
I mean, aside from whether you're within scope, and it's for argument's sake, let's say there is scope to introduce residential units as part of a hangar home. The question is whether that's appropriate doing so in terms of compatibility of residential living, because presumably there would be nothing to stop people living there 24/7, 365 days a year,
No.
as long as they parked up a plane.
Right. But we do have a piece on our title that it's about noise and the fact that any residential development or dwelling had to be built to X standard as well.
Yes, but that's not part of district plan requirements, is it?
No.
So we have the 60 decibel boundary is the one that runs along the southern boundary of the Jews Brothers land.
Yes.
Then the 50 decibel boundaries, the outer.
Yeah, so they, yeah.
Question.
We're just
In relation to this. So there are existing hangar homes at Port Aerodrome now.
I live in one,
how many are
Not intended for permanent accommodation,
but
but
we've got
Okay.
temporary only.
Do they have these noise controls restrictions?
Our one doesn't, but there is another one that was more recently issued under resource consent. So I have to find out what they've got.
Residents there.
But it's not uncommon for hangar homes, obviously, at airports. So we'll just have to find out what other controls have been put in place for that. there's a huge new one at Takofi near Hamilton, which is like 150 lot hangar home subdivision. That's like 80 hectares. So they've obviously got some sort of plan in place that we could probably find out.
60 dBA LEQ is a high level of noise to experience. In a normal situation, where the degree to which that's attenuated to a noise level was.
Yeah, that's along the southern boundary. So it's a very small part of the site that is within 60.
Same lot.
Yeah.
So one.
So you can say. Ryan's just pointing out that on the opposite side of South Road to the aerodrome itself is future residential and future urban, which is within that same area.
That's proposed by the.
Yes, but these hangars homes will be much closer than the areas on the north side of South Road.
Still within the
Still
same.
within the
Still
same
under that
exposure
line though.
contour.
Yeah,
Right opposite the road.
yeah.
And the other side of it is we're not taking off or landing in that area, so it's not, the noise is done from the runway, which is where all the noise has come from.
Helicopters?
No one's really
There'd be restrictions on helicopter use in that area for noise.
could do, but haven't.
I mean, there's a lot of detail here. We'll come back to that, but I guess what I'm trying to ascertain is whether a person reading the original submission would have understood that residential units occupied on a permanent basis would have been anticipated.
Definitely.
But clearly states.
And there's photos of exactly that within our initial submission.
Well, that's for Mr. Tom.
Yeah.
I'll send to satisfy us. So Charles.
Yeah.
Just to clarify, there are conditions on the designation that apply to residential activities, including
But only within the designation.
within the designation. So just to clarify for that question on what limitations are there are, and they're embedded in that designation.
Which they relate to noise.
Yes, so they all need to be acoustically engineered to meet noise standards. They need to meet the obstacle limitation service, and they each need to have a no complaints covenant registered on the property.
Which is already registered to our
We've already
title.
got it on there.
Can you bring some of those, well, it's not non-complaints, could you bring the acoustic standards into
Are they different from R14?
They refer back to, at the moment, actually, they refer back to the operative, which might be a matter to amend at the wrap up, but they do go back to the rules of the plan.
Yeah.
Yeah, that's probably historical.
I presume you could bring those rules into some of the permitted activity rules for a hangar home. Yes, standards, of course, couldn't you?
Yeah, at the moment we've got that reliance. So there's a rule, noise R14, which is noise sensitive activities within Hood Aerodrome air noise boundary. So it applies to all of them. And it's got a compliance is achieved with a noise standard 4, which I will just scroll down to, bear with me a moment. And a long standard, a list of standards here. And that specifies what sort of attenuations needed for those noise sensitive activities. The different types, like the external cladding with minimum surface density of 8 kgs per square metre, to get that density development.
So I just, your proposal here for a special purpose zone, it's quite a bespoke sort of solution to this complicated problem. And notwithstanding David's comments that it might be odd that it's just the only area there.
Yeah.
Would it fit nicely in your view is it stage 3 of the development of the airfield, so that rezoning, particularly on the other side of Menai Road when you're expanding, would you see this as a thing that would actually be open, or a useful zone to slowly extend as the plan gets developed?
I'd probably look at it another way, in that it would be much more useful if the airport had an underlying zoning of special purpose zone now, so designation 4A and 4B had it. And then that could be adapted for each of those areas that the master plan grows to as the master plan's implemented, because otherwise we're going to have this issue in perpetuity, which is kind of gives the answer to your question that yes, if a special purpose airport zone was introduced into the plan, that would be the natural zoning for that other
Be a logical solution.
to be. That's right. Yeah.
I can see this thing where you've got a tiny little part of the edge on.
It's
But is this just opening the door perhaps for expanding it across the whole
yeah,
area?
I think a good thing, because otherwise we've got another bespoke issue in the future that doesn't neatly fit the district plans offered.
Okay, there's a lot to unpack there. High level is the question of the HPL fine. Secondly, the scope issue of option 3. And I guess to a certain extent whether option 2 still is within scope.
Yeah, I'll discuss that with Mr. Malone, because there seems to be a little bit of confusion. Or
Yeah, and then the rest of it is detailed matters about the rule construct, how noise standards would have worked, activity statuses, policy direction.
yes,
Whether what's the issue I noted down earlier, visitor accommodation,
yes,
whether you're still pursuing that or not. Food and beverage, I think you've,
that's off the table.
yes,
Could be subject to
yes.
a consent winner.
The issue we have with time, just with timing, Mr. Anderson, the right of reply is due on the 4th of June, or around that time, just after Queen's birthday weekend, I think. That's 15 working days after the hearing. We have a integration and wrap up hearing just prior to that, on the 3rd, 26th. Yeah, week of, which will be the last hearing of the plan. Normally I would suggest that we could use that as a vehicle for dealing with any final matters that haven't been dealt with through conferencing, but the timing's probably not going to be conducive to that. I know you have some timing limitations over the next week or so. How do you think you'll be placed to, and the same applies to Ms. Falloon, to get together and work through some of these issues next week?
Next week is better than the following weeks. The Wellington RPS mediation starts Friday the 23rd. So that takes me out of action from then. So next week is, and this week, Waitaki District Plan takes up the rest of my.
How are you placed, Ms. Falloon?
From the hearings on Monday and Tuesday, I'm okay.
Yes, so Wednesday, Thursday of next week.
Wednesday, Thursday next week
Yeah.
is the clearest in my calendar.
I think you'll find that next week will just be the Monday.
Oh, yes.
Yes, and it'll be a reasonably short day. Yes. So Tuesday, Wednesday, Thursday. Do you need any further direction apart from what we've given verbally?
No, I'm comfortable with that, and I know I can come back onto recordings if anything needs to be clarified.
And okay, do you think you'll be able to give some urgent attention to that scope issue by Monday next week?
Yes. I'm confident on it. I'll write it up.
Any final questions of Mr. Anderson or the Jew brothers before we?
Thank you.
Thank you. Thank you for
Thank you.
accommodating
Thank you.
conversational side of the.
This is a good way to do it.
Someday, that's right.
Karen.
Yeah. Yeah, and yes, evidence.
Yeah. Sure, that's, they've got, I'll go for the council one straight.
Straight after,
Yeah.
so we'll be done.
Right. Yeah.
First part.
Oh, because they got a hearing next day,
Oh, right.
today. Yeah. So I'll just go over the.
So that's,
over the estate road.
Yeah. I'm trying not to attract
Yeah.
Marty. Just so you know, that's.
Yeah.
That's what it means.
Right. Actually, now for something.
Uh,
Yeah.
give me 30 seconds. Yeah, yeah.
Okay. Yeah.
We need in front of us is the summary statement, the graphic appendix 5. And the supplementary statement of. Good afternoon, Mr. Marshall.
Okay, Toe, how are you today?
This is your first time in person, isn't it?
Yes, no, I've been looking forward to coming to
Yes.
Wairarapa. It's nice to be here in person this time.
Yes, witness the crazy idiosyncrasies of Mr. McMahon firsthand.
It's been very interesting seeing these submissions that have been coming for you.
Yes. Thanks for your patience. And I know we've got Mr. Hudson and Mr. Broughton online.
So we have Mr. Hudson, Mr. Broughton, and Mr. Galbraith,
Yes.
all for Eastleigh.
Just, good afternoon, John. You're muted.
I'm muted.
Yeah, you've got your microphone on mute.
But,
Hi there, David.
John, good to see you again. Can you hear us? Can you hear us all right?
Yep.
Good. We can hear you loud and clear. Mr. Galbraith, good afternoon.
Good afternoon.
And Mr. Broughton,
Can you hear me?
hello. Yes, we
Good
can.
afternoon.
Thank you. And welcome to Ms. Foster. For last or second to last presentation.
Last. I think it's
Oh, sorry, Broughton. Sorry, Mr. Broughton.
Good afternoon.
Good afternoon.
I had, in terms of how to present the submission, I had proposed essentially to go through some legal submissions at the start. I appreciate that haven't been much in terms of legal submissions, and they can be fairly dry, particularly towards the end of the day. I'll try to keep them on point and don't propose to go through line by line, paragraph by paragraph, everything in the written submission. But just before kicking off that, I have received a message from Mr. Broughton that he indicated he might need to leave soon. So I might, if it's okay with you, he has, we have filed a statement on his behalf.
Okay.
He has been kind enough to appear essentially to answer any questions that you or the panel might have about his brief, which is short and relates to essentially the land in question and use.
Yes, the two terraces.
Yes.
Okay. That's okay. We'll accommodate that.
So yeah, in that point, I hadn't asked Ms. Broughton specifically to prepare a summary or anything because his brief is only 2 pages. It was more, I'd asked him to be here, and he's very kindly agreed in case the panel did have any particular questions about anything in his brief.
Have you had a chance to read Horton's
Yeah.
statement? What I should say is, and you might not have heard it, we had a presentation this morning from Ms. Falloon that took us through those parts of her summary statement that were still alive, if you like, based on the summary table that Ms. Foster put together. So we got a good grounding on the issues that are still in contention and those that aren't. So appreciate that.
Appreciate that. So may I take from that there aren't any particular questions?
I don't have any questions from Mr. Courtney.
Okay, thank you then. Thank you very much for being available. I appreciate it.
And that's because they're largely planning questions.
Yes.
As opposed, I mean, I saw Mr. Porter's statement as a statement of fact.
Yes, that was the intention there.
Yes.
So yeah, thank you very much. I'll let you go then.
Okay.
Thank you.
Thanks, guys.
Thanks.
In terms of legal submissions now, I do appreciate that Ms. Foster has been corresponding with Ms. Falloon, and many of the matters are agreed. Although of course I am mindful that agreement doesn't mean that the panel will necessarily accept them. I do propose to go through.
Do you have a hard copy of your legal submissions?
Unfortunately, only because I only have a hard copy of
We had them electronically.
We have.
Yeah.
I'll just share your screen.
Okay.
Apologies, I would have brought extra copies.
That's
But I just propose to go through some key points which I hope will assist the panel in terms of the matters that aren't agreed, and also on any some residual matters.
Yeah.
Ms. Flynn has Ms. Foster has a spare copy.
Scribbled on.
some on the
Yeah.
Thank you.
Yeah. These ones.
I mean, they are reasonably long, so
Yeah, I appreciate, and I'm not going to be going paragraph for paragraph, line by line. I'll just be sort of speaking generally, and then indicating where in the submission we've gone to a bit more detail. So just starting off, and forgive me if I am saying stuff that you are all aware of, but I just wanted to go through some of the more foundational planning law issues. So in my submissions, we made some general points about planning from paragraph 4. But jumping straight ahead to paragraph 7, there's a note there that the High Court has confirmed the approach to planning as being a top-down rather than bottom-up approach. So it's well-established approach to date. Turning to 9, I would like to refer to this Environment Court decision in Infinity Group and Queenstown Lakes Council. And I suppose this is quite an important decision that clarified that there is no presumption in favour of existing zoning when it comes to plan making decisions. And I know that, just quote the passage from the court, said, even so, we accept Mr. Goldsmith's submissions that there is no presumption in favour of any particular zoning of the site. And the next part, which I submit, is quite helpful, the court being required to determine the most appropriate zoning for the land. Now, this decision has been found 3 times since, including one decision from this year, and it is cited there, but Garden Trust and Auckland Council, which confirmed this. And I would note the court in that case confirmed the approach in Infinity Group and expressly rejected a submission that there needs to be some justification to depart from the existing zone, and the court said that wasn't an appropriate approach. Essentially, the question is, what is the most appropriate zone without regard to the previous plan?
which is essentially a Section 32 question, isn't it?
Yes, I believe so. The reason I raised this, and I think it will become, I hope it becomes apparent later, but from a practical point of view, I understand that the opposite when preparing the proposed plan, starting from the existing planning framework is obviously the most practical approach, because starting from a completely blank slate would be quite a big job. But I just emphasize that when we get to this point, the courts have given guidance that the previous plan is not a default or a presumption there.
Understood.
Thank you. And then, so I made a reference there intend to Hawthorne, and the Hawthorne decision emphasised the assessment when considering the existing environment. The question is not what's just physically there, but also what is authorised to be there under existing resource consents. And that ties into the national planning standards, which I've gone through at 13 onwards. But I note that the national planning standards have a there, which is to include standards that are listed in table 13 include zones that are listed in table 13 of the standards consistent with the description of those zones. And I would submit that the question of what is consistent with the description of those zones essentially incorporates a Hawthorne analysis of sorts, in which the panel, when asking, well, what is the zone, and does it actually is it in accordance with those descriptions, asking, well, what is the environment there, what is intended to be? That requires a Hawthorne analysis of looking at the resource consents in place.
Wasn't Hawthorne consenting judgment?
Yes, it was. However, I would submit that it is also relevant in terms of the more fundamental RMA question of what is the environment.
Understood.
Thank you. Regarding the national planning standards, and I go through this from 13 onwards, one of the key submissions I wanted to point out is that I've heard lots of reference to those standards, and obviously it's clear to the panel how important they are. It is worth noting that the reference to the standards in the RMA, in particular the direction in the RMA for territorial authorities to give effect to them in their district plans, is the same provision and the same reference which requires authorities to do that for national policy statements. So I would submit that essentially what that means is that standards have an equivalent status to that of the national policy statements. And that's why does that matter? The reason why that's relevant is the Supreme Court guidance that we received in the likes of New Zealand King Salmon case and the more recent Port Otago decision and the East-West Link decision, so that we can look to those to determine how should any inconsistencies, or I say perceived inconsistencies, between national policy statements and the standards be resolved. And I would draw attention to the, I think it was Justice Tipping's statement in the King Salmon decision, which said that it is appropriate to assume that when central government sets down national direction, they intend them to be consistent, and they don't intend there to be inconsistencies. And so when approaching the interpretation of those documents, interpretation should be preferred which are consistent.
Would that be nice?
Yes, and later on our submissions, we essentially say that supports or should influence the way that the panel interprets the NPS HPL.
It's interesting you say that, because under the now repealed NBEA, we would have a national planning framework that was going to provide a high level understanding of how different NPSs work together. And now I understand, based on current reform, as far as I've been keeping tracks on it, there's supposed to be a high level national policy direction provided. That's yet to come forward.
Yes, and it is yet to come, and yet to see whether it does actually improve things. But I would submit that in terms of the status quo, yes, we have national direction in separate documents, and also under sections. and it's not in a single framework in terms of a, say, a formatting sense. But I would submit that, following the direction we have from King Salmon, the approach should be that when these documents are made, they're intended to be interpreted as a coherent unit.
I understand that. I just have some difficulty reconciling that with what happens in reality when you're dealing with, on one hand, an MPS UD direction that's requiring identification and a national planning statement dealing with freshwater management or indigenous biodiversity that might require something else.
Yes.
So, but I know Ms. Foster's grappled with these issues herself in relation to some horizons issues.
And it is hard, and I'm not suggesting it's an easy job. I don't envy your position at the moment.
What's the point that you're trying to make?
The point I'm trying to make is coming down later when it comes down to some of the, and this is sort of leading into a point I'll come to later on the MPS HPL. So if you don't mind, I might just park that for one moment. I promise there will be a relevance to that. Now, so skip over a lot of my submissions here, almost coming up to 30. But before I get to that, I just want to make a note on one point which was raised in the summary that came out in recent days.
Yes.
And there appeared to me to be a suggestion that a plan change or a plan provision which sort of went a different way to a resource consent decision or an resource consent application that we declined in the past would undermine that decision. Now, I would submit that that isn't an appropriate way to look at the relationship between this process and past plans. When someone applies for resource consent, they apply for it under the policy framework that exists at the time, both national and local. They also apply for it under the environment that exists at the time. And even if those matters had not changed, this planning process sort of sits at a higher level, and it's appropriate that the panel might say, well, actually, under that framework, that wasn't appropriate, but we're here to decide on the framework.
Yeah, so that'll go to, using Ms. Foster's table as a reference, that'll go to some of the Southern Terrace and Northern Terrace and
Yes.
issues which have areas that are recommended not to be included at this point.
Yes, and I will signal that while I'm hoping that these legal submissions are helpful for all matters, a lot of this does go to that issue of the Southern Terraces. A note about the natural open space zone. I think there has been some concern that the zoning of current private property as a natural open space zone would set some sort of precedent or presumption that the land will be vested. I just want to submit that this is a zone, this is the plan only, and the council will be under no obligation to accept any vesting, even if rezoned.
Yeah, I think you might find there's been some movement on that.
Yeah, I thought there might have been, but it wasn't entirely clear if that was still up in the air or not. Thank you. Now, want to speak about the Southern Terraces. So that, because that is the main issue which still remains in disagreement between Ms. Falloon and Eastleigh's position here.
And just for your information, we have this very good graphic that was produced in Appendix 5 to the report.
Yes. So I think that the panel essentially has a planning problem here. It isn't an easy situation, and I want to acknowledge and emphasize here that this is not an easy situation to resolve when it comes to that particular Southern Terraces land, which is still in dispute, or there's still disagreement about how it should be dealt with. But this is why I spent some time talking about an affinity group at the start. I would submit it's quite important to set aside a presumption that just because that land was zoned the equivalent of general rural zone in the operative plan, that's sort of the starting point, and then there should be a default there. instead, what I would submit the appropriate approach here is for the panel to say, right, we have a block of land, we have direction in the national planning standards, which describes what, descriptions decide what zones should, exist and how, what descriptions they should accord with. That's, taking a top-down approach with the national direction. The next question is, what is the most appropriate zone for that block of land? And with that in mind, and I'm mindful that the witnesses are going to go into, the experts are going to go into a bit more detail about the actual status of the land. I'm not, I'm just a lawyer on that. However, just anticipating that, I have copied the descriptions, national zone from the zone framework standard back at paragraph 23 of the three, we say, sort of key zones, key questions of, what it seems to me, though, the three most sensible options would be. Now, looking at the general rural zone, you've got a description here, areas used predominantly for primary production activities, including intensive indoor primary production. The zone may also be used for a range of activities that support primary production activities, including, and then it goes on with it. The key issue there is that Eastleigh's essentially brought evidence that this piece of land, because it's been cut off and isolated from the rest of the land, has no reasonable productive use. There's no real prospect of this land in the short, medium, or long term being used for primary production.
Are you talking predominantly about the two gullies that we're talking about?
No, so this is
all area.
This is the southern.
Southern here. Sorry,
sorry, I'm make clear. This is the southern terraces I'm talking about. Sorry.
5 lots.
It's a ton.
Yeah, the tongue of land.
Yeah.
Yes. So from that point, I would say it's that a general rural zone would not be in accordance with that description and therefore would be contrary to the standards. Then I'd look at the second one is actually bottomless. You would ask natural open space zone. Well, the issue there is that that really hasn't been proposed, hasn't been asked for. Potentially an issue of scope on that, but also potentially I would suggest there could be an issue of takings there, because essentially you're taking a large block of land out of use. But in from a similar way, but just as with the general rural zone, I'd submit it's not appropriate. And having excluded those two areas, it seems to me that the correct choice, or the best choice out of what is not an easy solution, is settlement zone. So that's, and I think Christine will go into that further, but that's the points I wanted to make there from a legal perspective.
And you're drawing on infinity there for the question, what's the most appropriate zone?
Exactly, and particularly the this year's Auckland Council decision, which New Zealand almost doubled down on that point.
Thank you.
And skipping over some points here. I want to just briefly talk about the National Policy Statement for Highly Productive Land. This we've had in our submissions here from paragraph 36. I'm not going to go into the facts here. The reason why I'm raising it here is although I understand that there is an agreement in most respects with the 42A officer on these points, I just wanted to make a note and come back to the Hawthorne point that this land, at least Eastleigh has resource consents to subdivide this land, which it does intend to implement, and as such, the land has been removed from primary productive purpose. Now, looking to the NPS, yes, it is a directive policy statement, and I don't think anyone can deny that it's a directive policy statement, but it still requires the exercise of asking the question, well, what is it actually directing? And I would submit in engaging with that, what one needs to look at, what is its purpose? It's got an objective here of protecting highly productive land for primary production. Here we've got land which has already been removed. And an interpretation or submit an overly narrow interpretation of the NPS, which requires assessments at a level that do not actually advance the purpose of the policy statement. And on top of that, push a zoning which would be contrary to the national planning standards. So it would submit as not an interpretation that should be quickly followed. And to give give comfort to the agreement that I understand the 42A officer and Ms. Foster have reached there, I think that I believe that it is consistent with the NPS HPL interpreted in that light. And so that's the key point I wanted to make there. Unless you had any specific questions on legal matters, I'll then might move on to Mr. Hudson.
You seeking a ruling in our decision on the legal issue about whether there's a need for an assessment or not, or are you happy for us to adopt the agreement that's been reached between Ms. Foster and Ms. Falloon?
I'd be happy for you to adopt the agreement. I went into detail, just mindful that an agreement's not binding on yourselves, and I mean you'll include in your report, go into much detail as you think necessary. I think it also does go to the point where I think there was a memo from, is it Ag First? Yeah, Ag First, which suggested that it might anticipate some more assessment. And my comment to that would be that, well, actually, given the points I've just made, is an assessment greater than the information which has already been provided. And I would note that we're about to hear from Mr. Galbraith and Mr. Hudson, but it is in the context, a further assessment actually necessary, and I would say no.
All good.
Okay, thank you.
Clarification on your paragraph 40, when you talk about highly productive land and the issue of the consent arriving before that policy game starts. So just expand on that a little bit. So in terms of which takes precedence here, which is the authority here, the consent or
I would say that the consent defines the environment. And as a result, you have an environment where essentially you've got a plan which has been proposed with a general rural zone over a residential area. And when looking to the clauses in the NPS HPL and so it is a bit of a side, but there is a submission here also that noting that rezoning is not
defined a little bit for you. Just clarify the question. So you've talked about the 0.8 of a hectare that is WC3.
Mm-hmm.
In paragraph 40, you're going, the consent had already been issued, and to remove it from that. Is this a timing issue and a bureaucratic issue that a policy came into effect after that land had already been removed, but the maps hadn't reflected that, therefore you're caught in this trap?
Just like Ms. Foster.
I don't think the fact of the timing of the consents granted doesn't erode the relevance of the in other words, the national policy statement must still be considered. And then when we do that, we look at what is the land, the productive capability of the land that we're concerned about. And we say that the environment has changed. Yeah. So it doesn't erode your obligation to consider it. No.
But should people in your position be able to rely on a resource consent if the law changes subsequent? Which is effectively what's happened here, hasn't it?
Not for the purposes of implementing the resource consent, but for the purposes of affecting a zone change.
And it comes back to the Hawthorne point, and that I'd submit that the effect of the resource consent changes the environment from a legal perspective. What is the environment? And so then you ask the question, like looking at the NPS HPL, you're looking at productive capacity of the land. that those consents have changed the environment, and therefore, and I can refer to the definition of productive capacity, although I heard it quoted earlier. I imagine it's been quoted to you a lot, but that productive capacity, very broad definition, includes the physical environment, includes legal constraints, includes lot sizes.
I understand.
And that also includes the fact that those lots have been consented to be subdivided and used for a non-primary productive purpose. And as such, the productive capacity and the impact of a rezoning on the productive capacity is inherently limited because of that. So, okay, if that's okay, I might ask if we can speak to Mr. Hudson first. Mr. Hudson has asked that I read his summary from his statement, because he's had situation on ability to talk at the moment. So what I'll just do is I'll read through that, and then he's available online to answer any questions.
Just oh, this not. This is a summary statement that's just been produced, has it?
No, sorry, I mean his summary at the start of his brief of evidence, his executive summary. So he has not prepared a subsequent summary, and I would note that there hasn't.
Yes, sorry.
So that's his evidence. And so just reading from that, agreement has been reached with council officers that most of the lots should be rezoned as Riversdale Settlement Precinct. While I understand that the Section 42A officer's position does not bind the panel, I understand a legal argument will be made that what is approved by resource consent forms part of the environment. My evidence is only about the areas additional to those agreed to by the Section 42A officer. There is room for 6 lots at the front of the northern terrace, and there's reference to figure 1. The character of the whole northern terrace is settlement, and now the vegetation has grown, they are screened from below. I believe this was the reason that they were initially declined. In my opinion, they should be included in the settlement precinct. There are 4 lots, additional to the 6 above in item 4, internal within the northern terrace that were not included in the original subdivision. They are also shown in figure 1. I drew the layout for the original subdivision, and with the wisdom of hindsight and the expert help of the surveyor, I see how it could be improved. I recommend that the internal lots be rearranged to accommodate these 4. Lot 502 is a ton of land in the southern terrace on the immediate left when going up Rochdale Road, and would require particular landscape consideration, but is now no longer part of this application. The planting of the northern gully and frontage was done first, and the planting of both sides of the southern terrace and around the middle terrace was completed more recently. Replanting after droughts was also done where necessary. Much of this went well beyond the requirements of any resource consent and was done voluntarily by the developer at considerable cost. The effect of that has been to provide an effective softening of any residential development on the terraces. Previous hearing panels were asked to take on faith the planting we proposed. We are now able to demonstrate the effectiveness of that planting and can demonstrate that the caution previously exhibited was unwarranted. The planted areas are consistent with the natural open space zone definition and are inconsistent with the general rural zone definition from the perspective of a landscape assessment. That's a summary. I believe Mr. Hudson is available for answering. And if I might also just indicate very briefly, just yesterday, we did file a small bundle of photographs from Mr. Galbraith, which you may want to consider. But just
Yes. Could we bring up this graphic onto the screen for the northern terrace and share the screen so Mr. Hudson can see it?
Mine.
It's appendix 5 through on the summary statement. That's it. Thank you. Mr. Hudson, can you see that graphic?
Yes, it needs to move down. I can see it. It's only showing the southern terrace.
Yes, that's correct.
He was talking about the northern terrace.
Oh, sorry,
So page 3.
sorry. It's, graphic 3.
Yes,
Yeah, that's it. And it's the top there, isn't it? Oh. Is that the top red, as we're looking at the screen, the red portion closest to the top?
yes,
Yes, okay. And are you, is the green just below that has now been planted, is that correct? And that's what these photos indicate,
yes,
which
yes.
is now screening that portion outlined in red.
Yes,
Thank you. Yeah.
So just dealing with the northern settlement, northern terrace settlement zoning, Mr. Hudson.
yes,
You're saying that in relation to the 6 lots at the front of the northern terrace,
yes,
that over time there's been natural mitigation occurred through the growth that's occurred of the planting there,
yes,
and that would that wasn't there obviously at the time that the resource consent was considered and granted, declined for that part, and that change in the environment, to use Hawthorne for example, would be sufficient to allow those areas to come into the settlement zone. Is that your position?
yes,
That's a look down.
Yes. And the 4 lots internal within the northern terrace, they weren't included in the original subdivision, so there was no decision made because there was no application.
correct, yes,
Yes. Okay. And you're saying that with the benefit of hindsight, they could well have been included. Is that your view?
yes.
Going to move on to the southern terrace. Are there any other questions on the northern terrace from the panel? Okay, that's graphic number 1. So these are the is it 5 or 6 allotments? That's that's shown as 5.
There's 6.
Okay. So are they sitting below the road there, are they?
No, when the road flattens out, they're left with about level with the road, Rochelle Road.
Yes. Thank you. Any questions of clarification of Mr. Hudson on the southern terrace panel?
No.
Thank you, Dave. That probably takes us now to the gully areas. And that is graphic. Is there any issue in the middle terrace?
Bottom terrace.
Okay, on 2%.
I just asked a question on these gullies. Why have not been?
That's a question to Mr. Hudson or to?
Oh, to anyone that can answer it.
Yes.
Why are they? Is it not vested in the regional council, district council? I mean, regional councils have got all the tools to maintain a lot of area like this.
Yeah,
And
they
I'll-
shouldn't need much maintenance once they're grown.
Yes. But there's always predator control and the such too.
It's what?
Predator control, possums and all that.
Yeah. But there'll be that in the rural area as well.
Yes, I know, yeah, I understand.
Can I just say that we had Mr. Hudson, Mr. Galbraith and I had a little bit of email traffic on this question last night. Which was to say, and John, I'll just go back to a helpful email you sent, answered the question a little bit. And that was that the gully, there was some initial, interestingly, Andrew Scott, Eastleigh, contracted Greater Wellington to do the initial planting.
Okay.
They do it slightly less dense than Eastleigh does it. So I did that in 2022, 3 years gone. Mr. Galbraith went out and stood amongst it yesterday, and some of it was over his head, Manuka and that sort of thing. And John, what you said is that it's now, it'll take a bit longer and Eastleigh interplanted so that it is more dense.
Yes, in my opinion, it'll take another year to form a dense cover. The Eastleigh planting was done in 23 and the Greater Wellington Regional Council planting was done in 22. And I think you need to give them 3 years to match each other.
Yes.
Yeah, I agree.
And the point, I think, is that the stuff that is older than that has become sufficiently established that it's self-managing.
Yes.
Without management, there are not planting maintenance contracts in place, but it seems to be coping. Replanting has happened where droughts affected it, but John, am I right? Your view is that it will survive even if someone does nothing with it in the future.
Self-sustaining.
Yes, it will get there. It's just not there yet.
Yes, I understand that. We made a visit there a couple of months ago, and I was quite impressed with the way it was moving on.
I think everyone's been quite surprised, John, haven't they? And pleased by how successful it has been in a dry East Coast environment.
Oh, yeah.
Yes, it hasn't been easy to get them established.
That's why they call them indigenous.
Yeah.
That looks incredible.
The photo books have been very useful.
Yeah.
Yes.
I appreciate that. John, I don't have any further questions for you. Anything further from the panel? No. That's been very
No,
useful.
thank you.
Okay, thank you. So sorry about my voice. This thing affects the muscles in my throat, so I have to speak in. But hopefully that's answered all your questions.
It has, and you've come through very clearly, John. I think Councillor Pinner might have.
I just wanted to make sure Alice is happy with that now that you've heard the management that it's self-managing now. Are you comfortable with that now, or we?
Yeah.
Or do you need further? Because that's what that's what it's about.
Yeah, I think it'll be okay to leave it. It just needs a bit more time to form a canopy cover.
Yes. So the situation that Councillor Plummer was saying was just reminding Mr. Levine that you'll have an opportunity in a writer reply to revisit this issue and explain whether she still doesn't support the open space zoning or whether she does. Thank you for that.
It's suitable now to zone it as natural open space. It's just not quite suitable to give a good resource consent because of the conditions of the consent.
Right. Okay. Thank you, John.
Okay.
Next up, we have Mr. Galbraith, who's a special surveyor for Eastleigh. Chris, can you hear us?
Yeah, hi. Yep.
Look, I'm happy. You've got you had a pre-circulated statement also, Mr. Galbraith.
Yes.
Sorry, I just missed that.
You had a pre-circulated statement.
I did.
Yes.
I did, correct.
Are there any particular matters that you want to draw to our attention on that statement?
Well, I didn't think I need to read it in full. I had thought I could summarise a few points, if you think that would be beneficial.
And in your,
I think it's,
Self-explanatory.
Yeah.
My
The pho- the
statement
photo-
it relates to the issue of the highly productive land, which I know Josh has already talked to, and
Yeah.
Christine will be talking to, and also there is agreement from Alice also. So I wasn't sure whether that had been taken.
It has been taken as read, yes.
if I might clarify, the reason why we asked Mr. Gilbert to come and present that evidence was to just set a sort of a factual background or there for the benefit of the panel.
So I think we'll treat that in the light the same as Mr. Fortune's evidence. Statement of fact.
thank you for the photos, because we did do a site visit, but it's really good to have the visual in front of us during the hearing as well.
Oh, sure thing. No, there's plenty of photos there. I had to, cut them back to a few. But at least I was there on a sunny day.
You've got off quite rightly, Mr. Galbraith, so thank you for your attendance.
And I do have spare copies of that if I did bring it and anyone didn't have a printed copy.
Remove this statement.
Now, I was listening this morning, but I was in the car, possibly when Ms. Falloon gave you an update on her.
We took that out of order. So
Which is fine. So bear with me if I seem ignorant. I listened as long as I could. So I have a primary statement of evidence. I have prepared a hearing, a supplementary, speaking notes, having read Alice Falloon's supplementary hearing statement. And I heard yesterday that you anticipated a table, a super summary table.
I received it at 7:30 this morning.
Which I hope was helpful. So I go straight to that.
I think you should, yes. Did you have additional speaking notes, though, also?
The ones that we had previous.
Oh, those ones.
That's the job in they do. Yeah.
And you know what the areas are in contention, really. I think, I think the panel doesn't need to trouble you any further on item one. So it's really the terraces, the southern and the northern, and then you might want to comment on the NOS zone.
Yes, it's fine. I do have one little update, a difference, because we have had the benefit of some constructive discussions. Ms. Falloon and Ms. Chong and with Charles Horrell for MDC, altogether contributing to thinking of this along. And when I wrote my evidence, we were talking about perhaps in a precinct or within the sex zone, including reference to Riversdale Terrace's design guidelines. And we've moved away from that. So that's been superseded by time. We've slimmed it down. And no offence to the authors of the original design guidelines, but they're not really troubling themselves with things that a district plan would. There's a lot of stuff in there that is not written in the language of a district plan, and it's just going to get the council in trouble in the future. So we've focused on the thing that is of concern to officers, which is density and pattern of subdivision, and that's just a subdivision minimum lot area issue. So that is a difference from my original.
I mean, there's nothing just to stop those sitting outside the plan and be referenced by the developer if they were.
Well, we had a bit of email traffic about that as well last night with Mr. Scott in England. I wanted to know what the status of the guidelines is currently, and they are enforced through sale and purchase agreements, which has in some respects more force.
Are they backed up with the covenant?
With covenants.
Covenant.
And they are enforceable between the owners. So it's kind of self-enforcing. And it's stuff like burying your water tanks. You're not allowed to put stuff that are
fence sides, colours.
Like that's colours, things that I would be critical of otherwise.
Pets, all sorts of things.
Yes, that's right. Goes quite far, a lot further than the district plan does. But it is the reason that that those neighbourhoods have developed as they have.
Yes.
It's the answer to that.
Okay.
So residual issues, do you want to, let's have a look. So I've highlighted there's the differences with the 6 southern lots. There are a total of 9 in the total of 10. 9 of them, I do need to correct something. In the northern terrace, an answer that was given before, and that is that the 9 lots or versions of them were proposed in the 2004 application that was granted in 2005, and they were declined.
Yes.
The tooth gap was not included. None of us can remember why. So that's different. So total of 10.
Was suggested that it might have been an allotment for some stormwater outlet or servicing. That was something that came up this morning.
I'm going to ask, because I don't think it's fair that Chris Braith got no question.
Yes.
So, Chris, you went out there and specifically.
Yeah, hi. I have been on site, and I included a photo in the photo book, the last photo 9, which was not from my recent site visit last week. It's an older photo from, I think, several years back, but it shows the site in question, and
oh wow, yes,
it is an undulating site, but there's no sort of stormwater drain as such, and so in terms of development of that sort of tooth gap, I can't see any sort of obstacle to developing that site, and in terms of stormwater.
Okay.
Nothing that couldn't be resolved by when you put your lines, put it that way.
And I don't think Ms. Falloon had a particular concern with it. It was just an intrigue as to why it hadn't been included. But picking up on your point, Josh, that it's open now in terms of Infinity and
some questions we'll never know the answer to.
Yes. Okay.
So does that, are there any other questions about the north? Can I just talk about the, Chateria asked questions about, there's a lot of things going on in that image, but in the just below the words natural open space,
yes,
there's a little wee tongue of, that would be part of a reserve. It's a future reserve that's been accepted by the council on a subdivision plan. Either side of that are some hashed green bits. They are planted and they are on land owned by Eastleigh. My proposition would be that they are actually natural open space.
Yes, we asked Ms. Falloon that this morning.
Yeah.
And we got a slightly different answer. No criticism, but that her understanding is that would be retained as rural, but that was just showing the extent of the planting that's occurred.
That's right. That is what Eastleigh has done in response to Ms. Falloon's recommendation to say, well, we're content with that. I'm giving you a planning opinion about the fate of those two pieces. That's right. Yeah. It makes no difference to their future whether it is one or the other, but the zoning that actually matches what's there and prevents perverse outcomes for the people who might live above it one day is actually natural open space. There are also, there have always been ideas of a future pedestrian walkway through there to connect, even if it's just the small number of sections there, private perhaps, but these things over time they become public. But that's if you were visioning that.
Would there be any scope barrier to the panel adopting that?
I think that if you look at the neutral difference but in those terms between it's between settlement zone and a variation to make it natural open space zone. So I'm not certain. It would not be creating new adverse effects that are above and beyond that spectrum.
And on that point, I believe the go-to case I always think of on scope issues is Gertrude Salary.
Yeah.
I think they look the court said there to look at the difference between the effects of what is proposed versus the notified. And I think from that perspective, it should be in scope.
Some use the bridge and for fine. Okay.
So the only other thing I would say is, to my mind, it goes particularly the northern terrace, but the southern terrace as well. So if this is a visioning exercise, when a good strong easterly and the tide are lapping at Blue Pacific Parade some years, people would look back on this as a lost opportunity.
I just seek some clarification on that. Are you talking solely about the area below the term natural open space? Or are you also referring to the hatched area to the east of the red line?
If we're talking natural open space, both of those green blobs.
All the green hashed area.
Actually, when you look at it, you'll see that the green hash actually goes through the middle of that little wee sort of tongue, that little leg. So there's just a lot going on in that image. Yeah.
I guess from a planning point of view, it will be tidy to make that.
Yeah.
That's the extent of the northern terrace.
Southern terrace.
Yes.
See, it was originally designed to be part of a whole. So there was a historic decision. And we are left now with what I think is a simple planning problem. And it is simply a fire hazard now. And if there are concerns about prospects of visibility, we can talk about refinements and requirements that can be included in or activity status to ensure that those matters are addressed. The Eastleigh team thought they were quite fully canvassed. There are quite specific requirements about where one can build a house, how far away it can be from the edge of the terrace, therefore how visible, and
bulk location standards.
Bulk and location, height, ghastly things to do with colour, or just what the impact is, and style of roofing to match the contour, if you like, or the backdrop that you see. But in the
question for Ms. Falloon then is whether, if the panel was for the mind to include those fixed elements, whether we could rely on the standard provisions in the settlement zone to control them, or whether further controls were necessary. And is that where the precinct comes in?
I think the precinct provisions could be adapted, subject to advice about how. And Mr. Hudson's probably has a more qualified view than I do about this. It was his recommendation that there should be quite specific heights, building positions. John, do you want to just comment briefly on that? I think that the settlement zone is not as sophisticated as the set of controls on buildings that Mr. Hudson had recommended for this land. So, John, do you want to just comment on whether you think it is necessary to have
the controls that we recommended for that area were height, single story, maximum height of 6 metres, single story, pitch of roof, colour, material, setback, and we concluded that one house would have the same effect as 6 houses because of the positions, staggering positions that they'll be on. So if you are going to allow anything on there, you might as well allow the 6.
The Ripstone Terrace and
So I was just trying to read my note from this morning about how the precinct applied.
Just say that it's relevant to the point Mr. Hudson just made, that there are no dwellings on this particular parcel within the Eastleigh landholding. The vinculum, which it's called, the little thing that links it to the rest of the farm, it would have a house.
Yes. Okay, so there's an opportunity then to apply the precinct rules to this.
That's my recommendation is settlement zoning and precinct for here, with or without more specific controls, if be required, yes.
What's the essential difference in your view between the settlement zone and the precinct?
Reassurance for the council that the density will stay much as it is and was intended. That is the difference. The difference between 400 square metres and 1,000.
Yes.
Practically, you would struggle to get 400 on many of them anyway, because of the way they've been developed. It's not impossible, but people would have to lift architecturally designed homes. So that is the difference.
Is it solely a density difference since the precinct doesn't have any additional controls over and above the settlement zone that Mr. Hudson referred to?
Doesn't, no, it doesn't.
So those, Mr. Hudson referring to setback, colour, materials, those controls are all in the settlement zone.
No, there is no, the design guidelines have a coverage, the settlement zone does not. I misread it originally, thinking it was 200. That's for non-residential activities. It's nothing. It's a very, very simple zoning. It's a bit of a free-for-all, really. Yards, I think, setbacks are the only thing.
Yeah, and height, obviously.
Height, but it's, oh gosh, is it 8 or 10 metres?
I'm not sure.
In the zone.
The zone.
Yeah, I think it's 10.
I think it's 10, yeah. So I to be honest, I think the Eastleigh camp would be more comfortable with refinements that matter. Otherwise, you destroy the point.
Yeah. So could you report back on that, Ms. Falloon, about whether it's more appropriate? Well, the first question is obviously with appropriate zoning. But if it is to be settlement, whether it's more appropriate to have precinct. Is it an overlay?
I think it's strictly speaking, they operate as overlays, don't they?
It's still settlement zone though.
Settlement zone.
That's a settlement zone with the
One of the things that the standards have thrown in the works on that.
Could I offer to be more specific, to assist Ms. Falloon about what the prescription of those extra things might be? We can pick those out more quickly than she probably can.
That's good. I mean, an agreed statement or you conveying an agreed position in your ROR will be sufficient unless there's some disagreement. Okay.
Can I ask what the position, what the advice was you got about the natural open space zones? Is there anything further required of Eastleigh in respect of that?
No, that's not. Yeah.
No, pretty well sorted there.
Josh, is there anything further that?
No, nothing further.
Okay.
This has been really helpful.
Yes.
Well, that's the end of the presentation. Thank you for travelling over. Thank you for travelling down. We'll join. Thank you, Mr. Hudson. Thank you, Mr. Galway.
Thank you.
Thanks, John. Thanks, Chris.
Thank you, David. See ya.
And that's the last rezoning submission for the last 2 days. It's been one of the more interesting 2 days of hearings. My colleagues have all enjoyed it. It's something to get your teeth into as opposed to high level policies and objectives.
We love that part.
I must say, David, though, our visit to Riversdale has helped us immensely.
Oh, sorry. Just before we adjourn the hearing, just a housekeeping matter as it relates to Eastleigh. I'm conscious that the focus here has been on the settlement zone and the natural open space zone. In hearing stream 5, we had evidence on the special amenity landscape, SAL, and also on the inland extent of the coastal environment. I think Ms. Sweetley was on that? Yes. My recollection was that there were still some unresolved issues on that we may need to revisit at the integration period. And I can talk to Charles offline about that because Mr. Disney was involved in overseeing those after Sweetley left the team. So
Can I just say that from Eastleigh's point of view, those, if there were additional requirements out of that, they bite differently.
Yes, I
on
know.
controlled activity. That is essentially the difference, because Eastleigh is more relaxed about that, but yeah.
It was more about knowing what the officer's final position was, because I'm not sure if it was conveyed with clarity in the right of reply on those two matters.
It's on the extent of the coastal environment.
Yes, and also on the special amenity landscape as it applies to Riversdale.
Yes, and whether this rezoning, if it were accepted, would change that.
Yes. Well, yes, so there's two questions. What's the officer's recommendation on both the SAL and the coastal environment area? And then secondly, what's the implication if the settlement zoning is adopted by the panel? It's not being critical of the officers at all. I hasten to mention it's just I thought there were still some unanswered questions. Yeah. Yes. Thank you, everybody. The hearings hereby adjourned.